Donald Trump's hush money case. Donald Trump, of course, found guilty of covering up payments to adult film star Stormy Daniels just days before the 2016 presidential election. So Donald Trump's attorneys want his convictions frozen or dismissed so that Trump can get about the business of the people and run the country. Judge Juan Marchand was expected to rule on those moves by Team Trump today, but the judge instead kicked the can down the road, delaying his ruling until a later date.
So I need you to understand what just happened in that New York courtroom, because this is genuinely one of the most stunning legal developments in the entire Trump saga. During an appeals hearing on October 21st, 2025, Trump's own lawyers admitted under questioning that if presidential immunity doesn't apply to protect their client, then yes, he committed multiple felonies. They said it out loud, in open court, on the record. His own legal team acknowledged that the underlying acts in the hush money case, falsifying business records to influence the 2016 election, constitute serious felony crimes if the immunity shield they've been desperately clinging to doesn't hold up. And based on everything we've been tracking, that immunity shield is crumbling fast. Judge Marchand already stripped away broad immunity claims. The appeals panel was shredding their defenses during this hearing. And Trump himself reportedly got so furious at what was happening that he stormed out of the courtroom rather than sit there and listen to his own lawyers essentially confess on his behalf. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video.
Okay, so the extent of Trump's legal woes not limited to just this New York case. Of course, we know because we've been talking about it for months. Jack Smith's January 6th case, the classified documents case, and the Georgia elections case. So, Katrina, what happens to all of these cases?
Reed, as of now, all of the deadlines in the D.C. election interference case have been paused. That was at the request of special counsel Jack Smith, and he has until early December to tell the court how he wants to proceed. But it is anticipated that this is going to get dismissed. The question becomes whether that will be with or without prejudice. If it's without prejudice, it could be brought again at a later date.
Think about what this admission means for Trump's legal position going forward. His entire defense strategy has been built around immunity. The argument has been that he can't be prosecuted because he was president, and presidents get special protections. They've never really had a strong backup argument for what happens if immunity fails. And now we know why. Because if immunity fails, they've got nothing. Their own words confirm it. Without immunity, Trump committed felonies. That's not prosecutors saying it. That's not Democrats saying it. That's not media speculation. That's Trump's own lawyers acknowledging the legal reality of their client's situation in a formal court proceeding. They bet everything on immunity, and now that bet is looking worse by the day as court after court rejects their sweeping claims of presidential protection from accountability. The courtroom scene was apparently chaotic in ways that captured just how badly this hearing went for Trump's side. The appeals panel wasn't buying the immunity arguments. They pressed the lawyers hard on the specifics. They asked pointed questions that forced concessions the defense clearly didn't want to make. When the lawyers finally admitted that yes, without immunity, these acts would be felonies, reports say there were visible reactions throughout the courtroom. Trump's fury was evident to everyone present. Rather than maintain composure and sit through the rest of the proceeding like a defendant confident in his position, he stormed out. That's not the behavior of someone who thinks they're winning. That's the behavior of someone who just watched their last legal lifeline start to snap and couldn't bear to witness the rest of the collapse. This admission echoes what's been happening in Trump's federal cases, where the same all-or-nothing immunity strategy has been deployed with similar results. Judge Chutkan, in the January 6th case, ruled that the acts being prosecuted are not protected, stating clearly that no president has unbounded authority to commit crimes. The D.C. Circuit was unanimous in rejecting blanket immunity claims. The Supreme Court's own immunity framework, while giving presidents some protection, explicitly does not cover unofficial personal conduct like paying hush money to cover up affairs before an election. Every court that's seriously examined these immunity claims has found them insufficient to block prosecution. And now Trump's lawyers have essentially admitted that if the courts are right about immunity, then their client is a felon. That's the legal corner they've painted themselves into. Stick around because we're going to break down exactly what was said, why this admission is so devastating, and what it means for Trump's rapidly deteriorating legal position across all his cases. All right, so let's really examine what happened during this appeals hearing and why the lawyer's admission represents such a catastrophic development for Trump's defense. The October 21st, 2025 hearing was supposed to be Trump's opportunity to challenge Judge Merchan's rulings and potentially get his conviction overturned or at least significantly delayed. His legal team brought in heavy hitters from Sullivan and Cromwell, a prestigious law firm, to handle the appeal. They came prepared to argue that presidential immunity should have protected Trump from prosecution and that the trial court got the law wrong. What they weren't prepared for was the level of scrutiny the appeals panel applied to their arguments and the pointed questions that exposed the fundamental weakness of their position. The judges on the panel weren't just passively listening to arguments and nodding along politely. They were actively challenging the defense claims, pressing for specifics, and asking the kinds of uncomfortable questions that good appellate judges ask when they're skeptical of the arguments being presented to them. They wanted to know exactly how immunity applied to the specific conduct at issue in this case. They wanted to understand the limiting principles. If immunity protects this, what doesn't it protect? They wanted the lawyers to explain how paying off a porn star to hide an affair before an election could possibly be considered an official presidential act deserving constitutional protection from prosecution. And that's when the admission came. Under this sustained questioning, Trump's lawyers conceded the critical point. They acknowledged on the record that if immunity doesn't cover their client's conduct, then what he did constitutes multiple felonies: election subversion, conspiracy to defraud the United States, falsifying business records to influence an election. These are serious crimes that carry serious consequences. And Trump's own legal team admitted under oath in open court that their client committed them, with the only asterisk being their claim that immunity should prevent prosecution. But that asterisk is looking smaller and smaller as court after court rejects the expansive immunity claims they've been making. The admission was strategic in a sense because the lawyers had no choice but to make it. They couldn't argue that the conduct was legal because it obviously wasn't. They couldn't argue that the facts were different because the evidence was overwhelming. The only argument they had was that the conduct, while illegal, was protected from prosecution. But to make that argument, they had to concede the underlying criminality. It's a legal corner they painted themselves into by betting everything on immunity from the beginning. And now that bet is failing spectacularly, leaving them with an on-record admission that their client broke the law. Reports from inside the courtroom described the scene as tense and increasingly chaotic as the hearing progressed badly for Trump's side. The appeals panel wasn't just skeptical, they were actively dismantling the defense arguments piece by piece. They referenced Judge Merchan's earlier ruling stripping away broad immunity claims. They cited the Supreme Court's immunity framework that explicitly doesn't protect unofficial conduct. They pointed out that paying hush money to influence an election happened before Trump was even president and involved personal rather than official conduct. Every argument the defense tried to make ran into factual and legal obstacles that the panel clearly wasn't willing to overlook. Trump himself was reportedly present for at least part of this hearing, and his reaction to what was unfolding was visceral and visible. As his lawyers made concessions and the panel continued pressing, Trump's fury became apparent to everyone in the courtroom. He wasn't able to maintain the composed demeanor that defendants are usually advised to display. Instead, he reportedly stormed out of the courtroom rather than continue watching his legal team struggle against questions they couldn't adequately answer. Storming out of your own appeals hearing is an extraordinary action that speaks volumes about how badly things were going and how little confidence Trump had in the outcome. This behavior pattern, the visible anger, the dramatic exits, the inability to accept adverse developments calmly, has been consistent throughout Trump's legal battles. When Judge Merchan made unfavorable rulings during the trial, Trump raged on social media and attacked the judge personally. When the immunity stripping ruling came down, he reportedly rushed from the courtroom. When his lawyers make damaging admissions under pressure, he storms out entirely. It's the behavior of someone who expected his legal problems to simply go away and is genuinely shocked and enraged each time the legal system treats him like any other defendant subject to the same rules as everyone else. The hearing connected directly to Judge Merchan's earlier ruling that stripped broad immunity claims and set a swift December 2025 trial date despite defense objections. Merchant applied the Supreme Court's immunity framework and concluded that the hush money scheme falls outside official presidential duties and therefore receives no immunity protection whatsoever. Trump's lawyers appealed that ruling, hoping a higher court would disagree and restore the immunity shield. Instead, the appeals panel appears to be headed toward the same conclusion, that paying off Stormy Daniels to hide an affair during a campaign is not official presidential conduct and is therefore fair game for prosecution with all the consequences that implies. The admission also parallels developments in Trump's federal cases where the same immunity strategy has been failing consistently. Judge Chutkan ruled that the January 6th related conduct being prosecuted is not protected official action. She stated explicitly that no president has unbounded authority to commit crimes, a principle that seems obvious, but apparently needs to be spelled out when the defendant is claiming otherwise. The D.C. Circuit Court of Appeals was unanimous in striking down blanket immunity claims, with the full panel agreeing that the Constitution doesn't give presidents a free pass to break the law. Jack Smith has been granted access to White House records over immunity objections. Mark Meadows testified under immunity about Trump's dishonesty regarding the 2020 election. Across every case and every court, the immunity claims keep failing, and the evidence of criminal conduct keeps mounting. The lawyer's admission in the hush money appeal is particularly significant because it's not something that can be walked back or recharacterized later. It's on the record. It happened in open court. Multiple witnesses heard it. The appeals panel heard it directly from defense counsel. If Trump ultimately goes to trial in December without immunity protection, prosecutors can point to this admission and tell the jury, his own lawyers acknowledge these are felonies. The defense has already conceded the criminality of the conduct. All that's left is for you to find what everyone, including the defendant's own attorneys, already knows, that he's guilty of the crimes charged. So let's break this down into what you need to understand about this admission and what it means for Trump's legal situation as his immunity defenses continue collapsing across multiple cases simultaneously. First point, this admission represents the complete failure of the immunity-only defense strategy that Trump's legal team has relied on for years. They never developed a robust alternative argument for what happens if immunity doesn't apply. They put all their eggs in one basket, and now that basket is breaking apart in their hands while they watch helplessly. When you admit under questioning that your client committed multiple felonies, if immunity fails, and immunity is failing everywhere you look, you've essentially admitted your client is a felon. That's where Trump's legal position now stands. The strategic error of betting everything on immunity is now painfully apparent in retrospect. Trump's lawyers could have developed arguments about the sufficiency of evidence, about prosecutorial misconduct, about procedural irregularities, about any number of legal issues that criminal defendants typically raise. Instead, they focused almost exclusively on the claim that presidents can't be prosecuted, period. That claim was always legally dubious because even the most expansive readings of presidential immunity acknowledge limits when it comes to personal unofficial conduct. And now those limits are being enforced by court after court while Trump's team has no fallback position prepared. The admission will haunt every remaining stage of the hush money case and potentially other cases as well. Prosecutors can cite it in their arguments to the jury. They can reference it in sentencing memoranda if there's a conviction. They can point to it in response to any future claims that Trump didn't know his conduct was illegal or that he acted in good faith. His own lawyers said under oath that the conduct constitutes multiple felonies. That's powerful evidence of criminal liability coming from the defendant's own legal team. Defense lawyers in other cases will have to explain why the jury shouldn't draw conclusions from what Trump's attorneys admitted in the hush money appeal. Second point, Trump's behavior during and after the hearing reveals the psychological pressure these legal developments are creating and his inability to maintain composure when things don't go his way. Storming out of your own appeals hearing is not the behavior of a confident defendant who believes the legal system will ultimately vindicate him. It's the behavior of someone who's watching his last defenses crumble and can't emotionally handle witnessing it in real time. That emotional volatility is itself concerning for someone who holds the office of the presidency and has access to the powers that office entails. The pattern of volatile reactions has been consistent throughout Trump's legal battles during his second term. He attacks judges on social media when they rule against him. He demands impeachment of judges who find his arguments unpersuasive. He rages at his own attorneys when they can't deliver the results he expects. He reportedly rushes or storms from courtrooms when proceedings go badly. This is someone whose sense of invincibility is being shattered by the reality that the legal system still applies to him, despite his position. Every adverse ruling, every damaging admission, Every piece of evidence that emerges chips away at the narrative of untouchability he's tried to maintain. And his angry reactions reveal that he feels those chips acutely even if he projects confidence publicly. This psychological dimension matters for understanding how Trump might respond as legal pressure continues intensifying in the weeks and months ahead. Someone who storms out of courtrooms and attacks judges over adverse rulings is not someone who's likely to accept criminal accountability gracefully if and when it arrives. The question of how Trump handles potential conviction and sentencing is not academic. It's a live concern for everyone thinking about what happens next in these unprecedented proceedings against a sitting president. Third point, the appeals panel's aggressive questioning and the direction of their skepticism suggest this appeal is not going to succeed in restoring the immunity protections Trump desperately needs. When appellate judges press defense counsel hard enough to extract admissions that the client committed felonies, they're usually not doing so because they're planning to rule in the defense's favor anyway. They're doing it because they want to establish the record clearly before ruling against the appellant. The questioning at this hearing has all the hallmarks of a panel that has already reached conclusions unfavorable to Trump and is making sure the record reflects why. If the appeals court upholds Merchan's ruling, which appears increasingly likely based on how the hearing went, then the December 2025 trial date stands, and Trump faces a jury without immunity protection. His own lawyers have admitted on the record that without immunity, his conduct constitutes multiple felonies. The prosecution has overwhelming evidence, including the falsified business records themselves, testimony from Michael Cohen and others, and documentary proof of the payment scheme. The only question at that point is whether a New York jury finds the evidence persuasive, and given that a previous jury already convicted Trump on all counts, the answer seems pretty clear. The possibility of a convicted felon sitting in the Oval Office is no longer theoretical. It's approaching reality faster than many people expected. State charges like these cannot be pardoned away by the president because the presidential pardon power only extends to federal offenses. If Trump is convicted and sentenced in the hush money case, he has to serve whatever sentence is imposed unless and until the state of New York provides some form of relief. A president with a criminal conviction is unprecedented in American history and raises profound questions about governance, legitimacy, and the rule of law that we've never had to confront before. Fourth point, this admission and the surrounding developments connect to the broader pattern of Trump's legal fortress collapsing across multiple cases simultaneously in ways that compound each other. We've tracked Jack Smith obtaining access to White House records despite immunity objections. We've tracked the Bedminster recording where Trump essentially confessed to knowing he possessed classified documents he couldn't declassify. We've tracked Mark Meadows' testimony under immunity confirming Trump was dishonest about the 2020 election. We've tracked Judge Merchant stripping immunity in the hush money case and setting a swift trial date. Now we have Trump's own lawyers admitting in open court that their client committed felonies if immunity doesn't protect him. Each of these developments reinforces the others and accelerates the overall trajectory toward accountability that Trump has been trying to avoid. When immunity fails in one case, it weakens immunity arguments in other cases because courts cite each other's reasoning. When evidence emerges in one proceeding, it informs understanding of related conduct in other proceedings. When insiders like Meadows testify about Trump's dishonesty and criminal intent, it corroborates prosecutorial theories across multiple cases. And when Trump's own lawyers admit criminality under questioning, it validates everything prosecutors have been saying about their client's conduct. The legal walls aren't just closing in, they're converging from multiple directions simultaneously. The classified documents case, the hush money case, the January 6th and election interference matters. Each case has its own evidence and its own legal issues, but they all point in the same direction. They all reveal a pattern of someone who believes rules don't apply to him, who lies when it suits his purposes, who covers up inconvenient information, who pressures others to do his bidding, and who attacks anyone who tries to hold him accountable. The cumulative picture across all these cases is devastating for any claim that Trump is an innocent man being persecuted by political enemies. The evidence comes from documents, recordings, and testimony, including now from his own attorneys. So where does this leave us as we watch Trump's legal situation continue its rapid deterioration? We have his lawyers admitting on the record that their client committed multiple felonies if immunity fails. We have immunity failing in court after court as judges reject the sweeping claims Trump's team has been making. We have Trump storming out of his own appeals hearing in fury at how badly things were going. We have a December trial date approaching despite every effort to delay. We have prosecutors ready to present overwhelming evidence to a jury that won't be distracted by immunity arguments the court has already rejected. And we have all of this happening while Trump simultaneously faces the classified documents case, the January 6th investigation fallout, and countless other legal and political challenges. The admission in the hush money appeal may be remembered as a pivotal moment when the facade of invincibility finally cracked beyond repair. Trump's lawyers essentially conceded guilt while hoping immunity would save them. That hope is dying across every legal front. What remains is a defendant whose own attorneys have acknowledged his criminal liability, whose immunity claims keep getting rejected, and whose options for avoiding accountability are narrowing by the day. The trial is coming. The evidence is overwhelming. And now even the defense has admitted the conduct was criminal. Keep watching because the December trial date is approaching fast and the proceedings promise to be historic. A sitting president facing a jury on felony charges. A defense that's already admitted the underlying criminality. An appeals process that appears headed toward affirming the trial court's rulings. And a defendant whose behavior suggests he knows how badly this is going even if he can't admit it publicly. The legal reckoning that seemed impossible just a few years ago is now becoming inevitable. The only remaining questions are exactly when and exactly what the consequences will be. Stay tuned because this is far from over, and the ending is going to be historic one way or another.